Nobody stopped LG Polymers or the authorities of the LG Polymers to approach the government and take a permission to plug the negligence, to plug the damage, to prevent the damage, to take precautionary measures. Everybody is ready to issue passes. If they could have alerted the authorities, the government or the regulatory authorities or the district magistrate, that if they are not allowed to into the company to take the precautionary measures, the gas will leak and cause damage. If there is an application from their side to the government authorities, and if the government authorities still rejected their application, then they would have a case. Hi, today I am going to share with you about the application of law in Vizag gas leak case. Now, before understanding Vizag gas leak case, now let me brief you about about the incident. There was a company called LG Polymers, and they stored a gas called styrene, and that leaked and affected the neighboring village called Venkatapuram, and few people died and many were injured and hospitalized. These are the facts of the case. Immediately government, central government and the state government jumped into action and prevented the entire disaster, making it a bigger disaster. So everything is in control right now. The National Green Tribunal, which is a special court for action to be taken against environment, forests and climatic change. These are the special court called the tribunal. It is in every metro, but the Delhi metro, Sumoto took the cognizance of the case. Sumoto taking cognizance of the case means there is no need for any complaint. Court on its own can initiate a case. That is called the Sumoto taking cognizance of a case. Therefore NGT Delhi Sumoto took the cognizance of the case and registered the case and directed the government, central government, state government and LG Polymers and all the regulatory bodies, Pollution Control Board, concerned ministries, district collector of Vizag, and all other government functionaries will be there. All the government organizations and the regulatory bodies were made parties to the case, along with LG Polymers, because LG Polymers is regulated by all the central and the state governments, because it involved subjects of central and state government as per the constitution, which is environment and other forests and climatic change, etc. Now NGT, National Green Tribunal, which is a court, already passed an order directing the LG Polymers to deposit 50 crores, and the next date is posted for 18th of May of this month. Now let us understand, and why I am making this video is because the NGT used the two words which are very important in understanding the Vizag gas leak case and how the compensation will be paid to the victims, to the animals, to the nature, to the land, to the air, to the forest surrounding it, etc. The damage caused to entire environment, not only the individuals. The damage caused to the individuals is what we are seeing, but the damage caused to not only individuals, other aspects of the nature. So therefore, NGT passed an order directing the LG Polymers to pay 50 crores immediately and to deposit 50 crores immediately. Now what happens, we have to wait and see whether they will contest or not. But two words or the principle on which NGT passed this order was applying the principle of strict liability. Now this is surprising, that is why I am making this video. Now I will explain what is the meaning of principle of strict liability. It dates back to 1868, where there was a famous case called the Rylands versus Fletcher. The Fletcher is having a mine, and the Rylands was constructing a reservoir above the mine. He gave a contract to some contractors to construct the reservoir. They did not construct it properly, because when they were digging the reservoir, they found out that there is a mine underneath the reservoir, and they did not seal it properly. The contractors whom the Rylands employed did not seal the reservoir properly. So therefore the reservoir, when it was flooded, when it was filled with water, the water crept into the mines of the Fletcher, and therefore mines got damaged. The trial court made an order against the Rylands, who was the owner of the reservoir, who was the defendant in the case, and Fletcher is the plaintiff in the case. That is the Fletcher is the victim. Fletcher approached the court. So you can understand him as the plaintiff. And in the appeal, it was reversed. Rylands went for appeal, and in the appeal, the court did not accept the contention of the Rylands that notwithstanding he appointed contractors, he is liable to pay for the damage caused to the Fletcher. So therefore, the court evolved a principle called the no fault liability. Now strict liability comes from a source called no fault liability. Here Rylands was not at all liable. There is no fault of Rylands because he gave it contract to contractors to construct the reservoir. So he was not even aware of the type of construction, whether the reservoir was plugged, the reservoir while digging the reservoir, the mines were plugged or not is not at all even into the knowledge of the Rylands. So the Rylands tried to take a plea based on no fault liability, but the court in England did not accept plea of the Rylands and punished the Rylands. Therefore, Rylands lost the case, and it evolved a principle called no fault liability principle called the rule of strict liability. In the Vizag gas leak case, the essential elements are dangerous substance. It is a dangerous substance. It can escape from the possession of the defendant, that is LG Polymers, and it is for the non-natural use, that is it is for the commercial use. So therefore, all these three essentials of strict liability are there in the Vizag gas leak case. They can't escape. Now the exceptions, coming to the exceptions. Now here, what are the exceptions where principle of strict liability cannot be applied? When the defendant, that is LG Polymers, could take a plea that it is the fault of the villagers. No, he can't take that plea. Now, if LG Polymers could take a plea that it is the contributory negligence of the villagers, no, he can't take that plea. LG Polymers could take a plea that it is an act of God. Yes, they can take the plea of act of God or in the COVID-19 context, but still they can't escape because nobody stopped LG Polymers or the authorities of the LG Polymers to approach the government and take a permission to plug the negligence, to plug the damage, to prevent the damage, to take precautionary measures. Everybody is ready to issue passes. If they could have alerted the authorities, the government or the regulatory authorities or the district magistrate, that if they are not allowed to into the company to take the precautionary measures, the gas will leak and cause damage. If there is an application from their side to the government authorities, and if the government authorities still rejected their application, then they would have a case. In the instant case, whatever it appears from the newspaper reports, I find there is no such application with the government from the LG Polymers about alerting the government about the gas leak. If at all, they are not allowed into the industry. So there is a negligence. They can't take the plea of act of God. And the other is that act of third party. They even can't take the plea of act of third party. So now all the exceptions are against the LG Gas Polymers. Thank you. Thanks for watching. Bye bye. If you have any questions, kindly ask in the comment section.